Hi, I'm Matt Lewis with MLF Legal. Back again talking about general workers' compensation terms and how the system works. This is our series for this year. This is episode 25 in the series, and we're talking about how to dispute an impairment rating. And one of the most common fights in a workers' comp claim is maximum medical improvement and impairment rating. And there are many reasons why these fights occur. Maybe you haven't healed yet, so the impairment rating is premature. Maybe the impairment rating didn't include all of your injuries. Maybe the insurance adjuster wants to take a shot at knocking your impairment rating down a notch or two. But whatever the reason, if you're going to dispute the rating, you have to get off to the right start. The first thing you have to know is that you only have 90 days to dispute your first impairment rating. And there's a whole rule on this. And while there are some exceptions, it's pretty hard to meet the criteria. The second thing you have to know is that there can be more than one first impairment rating in your case. For example, if you win an impairment rating dispute and receive another impairment rating down the road, then this new impairment rating becomes the first impairment rating, and the 90-day clock starts ticking all over again. And this gets very confusing. Let's add to that confusion. There are only two ways to dispute an impairment rating. The first is by requesting the benefit review conference by filing form number 45. And this starts the litigation process. The second way is to request a designated doctor. And the problem there is that requesting a designated doctor doesn't count as a dispute if there has ever been a designated doctor assigned to your case before. So while there are two ways to file a dispute, both ways don't always work. The only surefire way to dispute an impairment rating is to file Form 45 and request a benefit review conference. At that point, time starts working against you because the litigation process at the division is fast-tracked. If you want to be successful in your impairment rating dispute, you must get another impairment rating that's different from the one that you're disputing. Remember that when you get in front of a judge, the judge has to rule based on the evidence, not fairness. If there's only one impairment rating in evidence, then there's only one choice the judge can make. You have to get a second impairment rating so the judge has the chance to rule in your favor. Here's a tip. If you have a doctor write a report explaining why you are not at maximum medical improvement and not yet ready for an impairment rating, that counts as a second report that the judge can adopt. Try that one out. So never get yourself into a hearing with a judge without the right evidence and a good argument. And when you need to dispute an impairment rating, we want to be your law firm. So remember to work safe, but if an accident happens, call MLF Legal.